As we've seen, the two most important features of the new American federalism designed by the framers are the dynamic nature of that federalism and the democratic nature of the new federal government. The framers recognized that the balance of power between the states and the federal government would need to change from time to time, and they trusted the American people to be in control of that ever-changing balance. Through this dynamic and democratic process, the framers hoped that America would gradually evolve in the direction of a single nation of American citizens. In this lecture, we'll examine how popular sovereignty, the power of the American people to control the course of American federalism, reshaped the relationship between the states and the federal government. We'll see how James Madison's plan elevated the power of the people over the power of the states. And we'll talk about the resulting change in the nature of American citizenship. The new draft Constitution that emerged from the Philadelphia Convention was the product of many compromises. And compromises tend to leave both sides unhappy. One of the constitutional compromises that certainly had that result was the compromise over slavery, America's original sin and the most reprehensible stain ever on our national moral character. Slavery was a matter of great controversy, even at the time of the framing. Slavery was also a matter that involved great personal contradictions. Despite their lofty beliefs and noble devotion to Enlightenment principles, most of the framers, including George Washington and Thomas Jefferson, owned slaves. All three of the co-authors of the Federalist Papers had at least some personal involvement with slavery. John Jay's father was one of the largest slave owners in New York, and Jay himself owned more than a dozen slaves over the course of his lifetime. At the same time, Jay was a leading advocate for manumission, the voluntary freeing of slaves, and he was a founding member of the New York Manumission Society in 1785. Prior to that, Jay unsuccessfully tried to add a provision abolishing slavery to the New York State Constitution. And later, as governor of New York, Jay signed into law the Act for the Gradual Abolition of Slavery in 1799, which eventually led to the complete abolition of slavery on July 4, 1827. Horace Greeley once wrote, "To Chief Justice Jay may be attributed, more than to any other man, the abolition of Negro bondage in this state." The historical evidence is mixed on whether Alexander Hamilton personally owned slaves, but he certainly participated in slavery. Hamilton married a wealthy New Yorker, Elizabeth Schuyler, who came from a slave-owning family. And Hamilton himself arranged for the sale and purchase of slaves for his in-laws. Hamilton, like Jay, was a co-founder of the New York Manumission Society, but it's perhaps revealing of the views of both men that the founding documents of that society did not take a stand on whether slavery should be abolished, and did not require society members to free their own slaves. Perhaps the most conflicted of the three co-authors was James Madison. Madison's father owned more than 100 slaves, and the family's Virginia plantation, Montpelier, depended on slave labor. James Madison himself was served by a trusted family slave while he was a young student at Princeton. Around the same time, Madison seems to have become persuaded that slavery was at least morally suspect, if not downright evil, and he often wrote and spoke about the subject during the 1780s. For example, at the Constitutional Convention in 1787, Madison argued that slavery was dishonorable to the national character, and that slaves should not be taxed because it would be wrong to admit in the Constitution the idea that there could be property in men. Nevertheless, after Madison inherited the Montpelier plantation in 1801, he made no move to free the family slaves. Moreover, when Madison became president in 1809, He actually brought along slaves to serve him at the White House. The Constitutional Convention delegates, despite or perhaps because of their own personal contradictions on the subject, knew all too well that slavery was the key issue that could blow up any chance of agreement. So, in the end, the new Constitution was drafted as a compromise, allowing the evil institution of slavery to continue into the new United States, and in fact, prohibiting the new federal government from abolishing the slave trade until 1808. In addition, the new Constitution provided that slaves counted as 3/5 of a free person for purposes of apportionment for both representation and direct taxation. This was a concession to the southern states, which feared that not counting the slaves at all would leave them at a political disadvantage when compared to the more populous northern states, and would someday lead to federal legislation abolishing slavery. Only 2 of the Federalist Papers deal directly with the subject of slavery. In Federalist 42, James Madison discussed the decision to allow slavery to continue in language that probably reflected his own personal conflict. According to Madison, it were doubtless to be wished that the power of prohibiting the importation of slaves had not been postponed until the year 1808, or rather that it had been suffered to have immediate operation. But the end result was a compromise, Madison argued, and it was better to have some future end for slavery than no end at all. As Madison put it, it ought to be considered as a great point gained in favor of humanity that a period of 20 years may terminate forever within these states a traffic which has so long and so loudly upbraided the barbarism of modern policy. Happy it would be for the unfortunate Africans if an equal prospect lay before them of being redeemed from the oppressions of their European brethren. Discussion of the apportionment issue also fell to James Madison. In Federalist 54, Madison explained that, under the prevailing law at the time, we must deny the fact that slaves are considered merely as property and in no respect whatever as persons. The true state of the case is that they partake of both these qualities. As Madison noted, in being compelled to labor not for himself but for a master, in being vendible by one master to another master, and in being subject at all times to be restrained in his liberty and chastised in his body by the capricious will of another, the slave may appear to be degraded from the human rank and classed with those irrational animals which fall under the legal denomination of property. At the same time, slaves were, at least in theory, legally protected against physical violence, even at the hands of the master, and they could be charged with violent crimes committed against another. This, according to Madison, showed that the slave is no less evidently regarded by the law as a member of the society, not as a part of the irrational creation, as a moral person, not as a mere article of property. The federal Constitution, therefore, decides with great propriety on the case of our slaves when it views them in the mixed character of persons and of property. For all these reasons, Madison argued, the constitutional rule treating slaves as 3/5 of a free person for purposes of apportionment made sense. He concluded, "Let the case of the slaves be considered as it is, in truth, a peculiar one. Let the compromising expedient of the Constitution be mutually adopted, which regards them as inhabitants, but as debased by servitude below the equal level of free inhabitants, which regards the slave as divested of 2/5 of the man." Of course, what the framers actually managed to do by compromising in this manner over slavery was merely to delay the inevitable. American politics soon became dominated by the division between the northern and southern states, as their economic as well as political interests continued to diverge. By the 1830s, this regional division had erupted into a major legal controversy. The specific cause of the controversy was the Tariff of 1828, a federal tariff law that South Carolina viewed as devastating to the interests of the Southern slave-based agricultural economy. In response, President Andrew Jackson's vice president, John C. Calhoun, a South Carolinian, asserted that South Carolina had the right to nullify federal laws that the state believed violated the Constitution. This claim of a state's right to nullify unconstitutional federal laws was based on the theory that the United States was originally created by means of a compact or contractual agreement between the states, and therefore the states should be the ones who get to decide whether or not a particular federal law or action violated the terms of the original agreement, namely the United States Constitution. Advocates of this claimed right of nullification argued that this was an implied right of the states, one that emerged inherently from the structure of the American federal system of government. Some advocates also pointed to things that were said during some of the debates at the state ratifying conventions, most notably in Virginia, indicating that the act of ratification was tantamount to the state agreeing to enter into a contract. Now, the Constitution itself says nothing about the compact theory or the claimed right of nullification. The Constitution's preamble begins with the familiar language, "We the people of the United States," at least strongly suggesting that the United States was created by the American people and not by the states entering into a compact. Moreover, the Constitution provides in Article 6 that federal law is the supreme law of the land, and in Article 3 confers upon the federal courts the power to decide all cases arising under this Constitution or under the laws of the United States. And in a series of cases dating back to 1809, the United States Supreme Court has consistently and repeatedly rejected the idea of state nullification of federal laws. The Federalist Papers, our most authoritative source for how to interpret the Constitution, speak pretty clearly on the subject of who gets to determine the constitutionality of a federal law or federal action. The most direct discussion appears in Federalist 39, authored by James Madison. There, Madison emphasized that the proposed new federal government's jurisdiction extends to certain enumerated objects only and leaves to the several states a residuary and inviolable sovereignty over all other objects. Madison then wrote the following key passage. "It is true that in controversies relating to the boundary between the two jurisdictions, the tribunal which is ultimately to decide is to be established under the general government. But this does not change the principle of the case. The decision is to be impartially made according to the rules of the Constitution, and all the usual and most effectual precautions are taken to secure this impartiality. Some such tribunal is clearly essential to prevent an appeal to the sword and a dissolution of the compact, and that it ought to be established under the general rather than under the local governments, or to speak more properly, that it could be safely established under the first alone, is a position not likely to be combated." Federalist 39 definitively answers the question of who gets to decide the constitutionality of a federal law or action. According to James Madison, it's the tribunals established under the general government, meaning the federal courts, that get to do that, not the states. The Federalist Papers also emphasize that this does not leave the states completely powerless to resist federal overreaching. For example, we've previously mentioned Federalist 44, where James Madison, in discussing the so-called necessary and proper clause of Article 1, Section 8, asked the question, what is to be the consequence in case the Congress shall misconstrue this part of the Constitution and exercise powers not warranted by its true meaning? Madison's answer was twofold. First, such a usurpation of power by the federal legislature would be unlikely to occur because it would require the collaboration of both the federal executive and the federal judiciary. And second, in the last resort, a remedy must be obtained from the people, who can, by the election of more faithful representatives, annul the acts of the usurpers. This political last resort could be facilitated by the states, which could sound the alarm to the people. But there's nothing in Federalist 44 to support the idea of direct state action to nullify an exercise of federal power. Enforcing limits on federal government power was a matter ultimately for the American people, not the states, to decide. Similarly, we've seen how in Federalist 45 and 46, the two great essays by James Madison that explained his brilliant political solution for maintaining the balance of American federalism, Madison discussed at length what the states might be able to do in response to possible federal encroachments. In Federalist 46, Madison wrote, "The means of opposition are powerful and at hand. The disquietude of the people, their repugnance and perhaps refusal to cooperate with the officers of the Union, the frowns of the executive magistracy of the state, the embarrassments created by legislative devices, which would often be added on such occasions, would oppose in any state difficulties not to be despised, would form in a large state very serious impediments, and where the sentiments of several adjoining states happen to be in unison, would present obstructions which the federal government would hardly be willing to encounter." So, basically, if the federal government ever tries to grab too much power, state executives can frown about it, and state legislatures can throw up devices in opposition to try to embarrass the feds. But in the end, according to Madison, it's always up to the federal government to decide whether, even in light of such obstructions, the challenged federal action is worth pursuing. And the American people can always control the federal government through their power to elect new federal officials. The state remedies for federal encroachment discussed in Federalist 46 fall far short of the claimed right of a state to nullify federal law. Of course, Madison also wrote in Federalist 46 that if the federal government did not respond adequately to such concerted political pushback and insisted on following a path that would lead to tyranny, the American people would always hold the ultimate trump card. That trump card was the threat of another armed revolution, fueled by the American love for liberty and the guns that the American people chose to retain so that they'd always be ready to serve in their respective state militias. But that's a trump card I'm sure James Madison hoped would never come into play. Interestingly, the compact theory and the related idea of state nullification first arose during a very early American political controversy, only a few short years after the Constitution was ratified. And it was a controversy that directly involved James Madison. In 1798, during the John Adams presidency, Congress, then dominated by members of Adams's Federalist Party, enacted 4 statutes collectively called the Alien and Sedition Acts. The 4 statutes included the Naturalization Act, which greatly increased the residency requirement for immigrants to become citizens, the Alien Friends Act, which authorized the president to imprison or deport non-citizens deemed dangerous to the peace and safety of the United States, the Alien Enemies Act, which granted the same authority with respect to male citizens of any hostile nation during war, and the Sedition Act, which made it a federal crime to falsely or maliciously criticize the federal government or federal officials. The Federalists who enacted these laws argued that they were needed for national security due to recent naval hostilities with France. But their political opponents, the Democratic-Republican Party of Thomas Jefferson and James Madison, believed the statutes were politically motivated because most immigrants to America at that time supported the Democratic Republican Party. So Jefferson secretly drafted a resolution called the Kentucky Resolution of 1798, arguing that under the compact theory, the states possessed the right to judge the constitutionality of federal laws, and that the Alien and Sedition Acts were unconstitutional because the federal government had been given no enumerated power to deport aliens or to enact the criminal provisions contained in those acts. Jefferson's draft of this 1798 resolution also included language supporting the idea of state nullification, but that language was deleted when Kentucky's legislature passed the resolution. A year later, after no other state had agreed to join the Kentucky resolution, the Kentucky legislature passed a new resolution, claiming that the several states had the right to nullify unconstitutional federal laws. The 1799 resolution didn't rally the other states either. In fact, 7 states formally rejected the Kentucky resolutions, while 3 others passed their own resolutions expressing disapproval, and the remaining 4 states took no action at all. Meanwhile, in Virginia, James Madison also secretly drafted a resolution called the Virginia Resolution of 1798. In it, Madison took a more moderate view than Jefferson, claiming only that the states had the right to interpose whenever the federal government acted in violation of the Constitution. What did Madison mean by interpose? The text of the resolution didn't say, but maybe Madison was referring to the kinds of relatively soft political opposition he'd written about in Federalist 44 and 46. Once again, though, no other state agreed to join the Virginia Resolution. In January 1800, the Virginia General Assembly, responding to criticism from other states, issued the so-called Report of 1800. This report, which was also written by James Madison, explained that, although the states had the right to declare a federal action unconstitutional, such a declaration would be solely an expression of opinion, without legal force or effect, because only the federal courts had the authority to provide legally binding interpretations of the Constitution. The purpose of such a state declaration of unconstitutionality would be purely political, to mobilize public opinion in opposition to the challenged federal action. Such a declaration could provide a basis for reaching out to other states, which could eventually lead to petitioning Congress to change the federal law, or perhaps even to calling for a new constitutional convention. Once again, this all seems to echo the way that Madison wrote about state resistance to federal encroachment in Federalist 44 and 46. Despite the failures of the Kentucky and Virginia resolutions, the political controversy over the Alien and Sedition Acts played a significant role in the presidential election of 1800, in which Thomas Jefferson defeated John Adams and the Democratic-Republican Party took control of the federal government. This was a clear vindication of James Madison's belief that state resistance could help mobilize the American people and bring about needed political change at the federal level. By the time Jefferson was sworn in as president in early 1801, some of the most controversial portions of the Alien and Sedition Acts had already expired or were about to expire. But dozens had already been prosecuted and many convicted for crimes under the Sedition Act, including a number of anti-Federalist newspaper editors. Also convicted for violating the Sedition Act was one Luther Baldwin. At a parade for President Adams in Newark, New Jersey, Baldwin, more than a little drunk, had responded to a friend's comment about a 16-gun salute for the president by stating that he did not care if they fired through his arse. For that, Baldwin was convicted and fined $150. By the way, one remnant of the Alien and Sedition Acts still survives today. The Alien Enemies Act remains in effect, and has been invoked during such modern political controversies as the imprisonment of Japanese, German, and Italian citizens during World War II, and the imposition of a travel ban against citizens of predominantly Muslim countries during the early months of the Trump administration. Let's return now to the nullification crisis involving South Carolina and the Tariff of 1828. In 1832, South Carolina passed an ordinance of nullification, barring enforcement of the new federal tariffs within the state on constitutional grounds. President Andrew Jackson threatened to use military force to enforce the federal tariffs. No other state backed South Carolina. James Madison, then in his 80s, wrote a public letter denying South Carolina's claimed right of nullification, and also denying that the Virginia Resolution should be read as supporting it. In the end, a compromise was reached, replacing the objectionable tariffs with new versions more palatable to South Carolina. So, federal military action became unnecessary. Once again, though, this compromise only delayed the inevitable. The moral and legal struggle over slavery continued, and the political rift between the northern and southern states continued to deepen. Battles over the federal Fugitive Slave Acts, which required the return of runaway slaves to their masters even after those slaves had reached free states, led to efforts by several northern states to nullify those federal laws. These efforts were rejected by the United States Supreme Court, just as all previous attempts at state nullification had been rejected. Eventually, in late 1860, South Carolina declared its formal secession from the Union. In its declaration of secession, South Carolina specifically cited the repeated efforts to nullify the federal Fugitive Slave Acts as one of the causes for secession, because such efforts showed that the original constitutional compact was already broken. Of course, the outcome of the Civil War put a final and conclusive end to the argument that the states possessed the right, under the compact theory of the Constitution, to nullify federal law, as well as the argument that they possessed the right to secede from the Union. The federal government, backed by the northern states, fought a war to prevent secession and preserve the Union, and the Union prevailed. The strong version of states' rights, reflected in the idea of state nullification, died with the Confederacy. Today, we often think about the Civil War solely in terms of the struggle to end the evil institution of slavery. And indeed, the Civil War was mostly about slavery. But it was also about federalism. The Civil War represents the single greatest shift in American federalism since the framing. Recall that before the Civil War, Americans mostly thought of themselves as citizens of their own state. They looked to their states to protect their basic human and civil rights. But the great and hard lesson of the Civil War era was that you can't always trust your own state to protect your rights. The experience of blacks in the South proved that point beyond debate. The Southern states simply couldn't be trusted to protect the rights of their own black citizens. So the federal government had to go to war against those states to do so. This experience fundamentally changed how a majority of the American people thought and felt about the concept of citizenship. Shortly after the Civil War ended, 3 constitutional amendments were proposed by the Reconstruction Congress and were quickly ratified. Those 3 amendments, 13, 14, and 15, are today called the Civil War Amendments. The 13th Amendment abolished slavery, and the 15th Amendment provided that the right to vote shall not be denied or abridged on the basis of race, color, or previous condition of servitude. But I want to focus here mostly on the 14th Amendment. Every law student in America learns that the 14th Amendment contains the constitutional guarantees of due process of law, as well as the equal protection of the laws. Those specific guarantees have led to many famous Supreme Court decisions, including the ones that required the states to desegregate public schools, to reform their criminal justice systems, and to recognize same-sex civil marriages. But many students remain unaware of the true significance of the first sentence of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This language is the key to understanding the huge shift in American federalism that occurred as a result of the Civil War. The first sentence of the 14th Amendment expresses the new vision of American citizenship that emerged from the Civil War. It's a constitutional declaration that if you're born or naturalized in the United States, you are a citizen of the United States first and of your state second. And it's a solemn promise that from this point forward, it's the federal government that will protect your basic human and civil rights, even against your own state, and even through the use of military force if necessary. The remainder of the 14th Amendment outlines some of the specific ways that the states are constitutionally prohibited from infringing your rights, but it's the first sentence that explains why. After the Civil War, and especially after the Civil War amendments to the Constitution, the concept of American citizenship changed, which meant that the balance of American federalism changed. The federal government suddenly became much more powerful, taking on the new and immense responsibility to protect the basic human and civil rights of all American citizens. This huge shift in the balance of American federalism happened because a majority of the American people wanted it to happen. The American people lost confidence in the states, and they turned to the federal government for a solution. The American people exercised their constitutional authority to alter the original balance of power between the federal government and the states. And that's exactly how James Madison and the framers designed the dynamic system of American federalism to work.